going to start the day. Good morning. We're going to start the day with Judge Meineke. It's a little bit of a quiet start to court this morning, but Judge Meineke is holding his sobriety court. So these are people who have had struggles with alcohol, one or more DUIs. I don't know. Judge Meineke's in Royal Oak, Michigan. I don't know if it's in his court, if you need a second offense to get in sobriety court. Some you do, some you don't. But regardless, let's start the day off a little bit different and take a look at some people who are trying to fix themselves.
A long ride. It's going to be very roomy and taxing. It's going to it's going to take a lot of work, but you can do it because I've done it. I'm doing it. So I was happy to be able to tell them the little steps that I had taken, and once I had completed the task, I don't remember it, boys. I just know I did it. It was a lot, and so I moved on. But
Do you know what court it was in?
I want to say Southfield. It was in Southfield. I'm not sure, but he was due to get his tether the next day, and I said, "Yeah, that's kind of when I went to court, and he had to go get the tether." Oh, and you have to pay for it. I was like, "Oh, I have no money." Yeah, so that was good. That was good.
I just like that in his moment of crisis, he picked up the phone and thought,
Yeah, because I wasn't associated. I haven't seen you. And at that time, he had already caught a DUI, but he was still drinking and smoking. And I'm like, well, how are you on probation and you doing all that? So I had been distant. So I had to be really, I don't have time for that. I have something to do.
Right.
So I just been on task, and at times, I can be a little snarky.
really? I've never noticed.
Just a tad, under pressure, anxiety, stress. So I'm still working on that. But at the same time, I've learned how to deal with it without alcohol or mood altering substances. So I'm very proud of myself and very, very thankful and grateful for the opportunities, especially. So yeah, I'll be back to visit. Absolutely.
You should be proud because again, like you say, snarky, but I also will say, like, you were strong-willed. I'll use that instead. You were strong-willed. And for me, now again, it's not like you're gonna get it right every single day. And there'll be days where you still might find yourself being a little bit more unpleasant than you want to be, okay? But you've channeled that energy, all right? And there's a ferociousness in which you have really attacked your sobriety. You really have made sure that anybody who, any sort of temptation, any sort of negative energy, like you're like, I don't have time for that. I don't have time for that. And so you've taken maybe what would have been something that would have kept you down, kept you negative, and you've used that ferociousness in defense of your sobriety, in your determination to keep what you have now. Like that's what I need to see. That when we're not, Anya, and we're not, you don't have to report back to us that same determination exists whether we're present or not. And that's the most beautiful thing, is like we've taken that, we've harnessed that snarkiness, and we've used it to properly defend this incredible thing that you've built. And you're right, you should absolutely be proud of yourself. We are so proud of you, Ms. Hayden. It's hard for me to even, I'm gonna work on it because I want to be able to put into words how I feel about you, how I feel about your mom, how I feel about this whole journey, getting to know your whole family, it's been an absolute gift. I've enjoyed our conversations, and I like a little snark. My mom has a little snark, okay? All right. I'll probably be in trouble for that because she's gonna see this. I love you, Mom. So, we've done some good work together, Ms. Hayden. And I'm counting on you to pop in from time to time and say hello. But it's gonna be a challenge for me to put together in words how strongly I feel about you, and I'm looking forward to our graduation. All right. So I do want you to check in with Tom and Peggy at your penultimate review. So and then I think we have one graduation today, and when that happens, after that, you're all set today. Okay.
Okay.
All right. Good to see you.
March 25th.
March 25th, graduation.
Where she's
Right, Mr.
living, I
Rhodes?
guess. So I guess, she's partially blaming, I guess, the Jody Woods husband.
Okay, 2301-817.
Mr. Rhodes, he's doing well. As far as his testing, he had one test where he missed, and he was unable to test the next day due to the testing facility closing due to weather, but he did test negative that next day. And then
But
one
she
delay,
failed to
on the
appear back
17th
in
at
February.
6.9, but all other testing is negative. Going to his meetings, working with his sponsor, attending his counseling, did a very good job at his homework.
Very good. I was really pleased. And I heard through the grapevine that somebody said 9 months?
9
So,
months.
yeah.
9 months, and when was that?
May 27th. I mean,
February 27th?
yeah, February.
Okay, because May 27th will be a year, right?
No, I thought you meant since the last time.
Well,
Yeah, yeah.
it's 9 months of sobriety on February 27th.
Correct.
Okay, good. Now we got that out there. 9 months of sobriety. All right. This is brilliant. I couldn't be more pleased with the way you stepped up. Particularly, I feel like you've really stepped up in the past few months in particular. When you've had different challenges that have happened, it really would have been easy for you to, lose your momentum, lose your stride, but you haven't. You stayed locked in, and it's been a sight to see. So I just ask you to continue to be vigilant, okay?
Absolutely.
Ms. Tracy, what's your recommendation for today for our friend Mr. Rhodes?
That he be promoted to page 3 today. Yeah.
I agree. The homework was excellent. The work that you put in place has been undeniable, okay? I couldn't be happier with where we're at, but again, I agree. I want more, and so should you.
100%.
All right?
Getting ready to.
I love it. I love it. All right, so can we celebrate with our friend Mr. Rose as he promotes to phase 3? All right, there we go. All right, that's a point.
It's good to see people fixing themselves. So often in court we see people and their worst moments, so it was nice to take a few minutes here to start the day and see some people who are trying to correct themselves. Let me know what you think in the comments in the chat, but I personally really appreciate that. Let's go over to Judge Middleton and see what he's got going on. He's doing pre-exams, I believe.
All right, welcome back, Mr. Terry. Let's more formally address this case.
Oh.
Yeah, I can't.
They used to have it.
All right, the allegation in this case, this is file number 25334 FY, is that on February 24th of this year, Mr. Terry did possess firearms by a prohibited person. That's a felony punishable by up to 5 years imprisonment, fine of up to $5,000. Did possess ammunition by a prohibited person. Did possess metallic knuckles and reckless use of a firearm as a habitual second offender. Making the maximum punishment here 7.5 years. The complaining witness was Gina Leister, who was, I think, Mr. Terry's probation officer. Mr. Terry, are you on probation to the circuit court?
No, sir.
All right. Is that revoked or you're off paper?
No, I'm in LaGrange County. I was on probation. It was Sally Niedermeyer is who my probation officer was.
Is
Gina
that
Leister
done?
is my-
I know Miss Leister, I believe, lives near Mr. Terry.
She was my
Oh,
neighbor.
so she is not a PV, but she's just a witness. All
Yes.
right, Mr. Josh Robert, Chief Assistant Prosecutor, is here. What is the plea offer in this case?
The offer is for the defendant to plead to count 4 firearm reckless use with an agreement that he be placed on probation. Seemed like this was mental health and maybe substance abuse related.
All right, well, let's talk about count 4. Reckless use of a firearm is a misdemeanor. As long as no one's injured, it is punishable by up to 90 days in jail and a fine of $500 to $500, and it could suspend your hunting privileges. Do you understand?
Yes, sir.
Mr. Terry, are you going to plead to that misdemeanor charge?
Yes, sir.
All right. Other than that, did anyone promise you anything to get you to plead to this?
No, sir.
Promise you anything?
No, sir.
Do you understand that if you plead to this charge, you'll be giving up your right to have a trial in front
Yes,
of a
sir.
judge or jury?
Yes, sir.
If you had a trial, you'd have the right to be represented by an attorney. If you could not afford an attorney, the county could appoint one for you at county expense, which we have done. If you had a trial, you'd have a right to have any of the witnesses for or against you subpoenaed to come to court so they could be questioned under oath. You would have the right to take the witness stand yourself and testify on your own behalf, but you don't have to because you have a right not to testify. And if you did not wish to testify, the judge or jury cannot hold your silence against you. So this is a pretty good plea offer. All the felonies are dismissed for a plea to this one misdemeanor. Other than that, did anyone promise you anything
No, sir.
or threaten you?
No, sir.
All right, what happened on February 24th?
I had found paperwork to prove a case that proved my innocence about going to Pivotal. It was just a receipt, and I found this in my house, and it wasn't there. And I was questioning my dad about it. He had came home from work and came inside for a while and sat down and talked. And then when I showed him the paperwork, he kind of like,
Mr. Terry, I think Judge is mostly asking about when you had the firearm and your use of the firearm. If you want to skip.
I had the gun outside in the yard, and I pointed it towards the field and knew that the field was an open field and shot it off in the air one time. And then my father left. And then I was sitting out in the driveway when the police came in.
Why did you do that? Because you were upset?
Yeah, because I figured, being a felon with a firearm, I knew that if I didn't hurt nobody or didn't actually, shoot anybody, that I thought that was my way of trying to, without being a snitch or calling the cops, because I know my cousin has control over my phone and she gets all my calls and stuff. So if somebody called the cops on me and I wasn't hurting anybody, I knew that, I
All
could,
right. What time of day or night was this?
about 5, 6 o'clock.
Was it dark out?
No,
Had you been drinking?
no, sir.
Using any drugs?
Yes,
Which drug?
amphetamine.
So mostly you shot this because you were upset and you just wanted to kind of make a statement?
Yeah.
All right, what's up with the brass knuckles?
I have had somebody shoot a power box out next to the house, and people have been like hunting dogs all night long around there, like recklessly using firearms. So if I wasn't supposed to possess one and I didn't have one, I wanted to have some kind of form of protection. You usually don't
Well,
take a knife
brass
to a
knuckles would
gunfight,
not be a
but
very good protection from somebody with a gun.
you're right. But if I couldn't get a firearm, I would.
Mr. Terry, I don't want you to admit to crimes that are not part of the plea agreement.
Thank you.
All right. Well, I've got enough for careless, but I'm gonna sentence him. If I can't ask him that, I might as well just give him 90 days in jail. He has a previous gun charge from 2021. He also has a number of unpaid fines and costs, but he had a felony gun charge that was reduced to attempted possession of a loaded firearm. And that didn't go all that well. Let me look when that was, 21. You mentioned pivotal. You also got extradited to LaGrange. Are you off probation in LaGrange? I think you told me you were done there. Are you still on probation in LaGrange?
No, sir.
All right. Yeah, that gun charge was in 21. You did eventually pay it all off.
Sir, I
Gun
PR'd
got
out, but
forfeited.
they couldn't produce any evidence against me. They took my gun on the side of the road, but then they couldn't produce any evidence against me. So after 6 days of being in here, I PR'd out.
It was 4 days according to this, but all right, you mentioned pivotal. Are you on supervision of pivotal now?
No, I'm speaking with them while I'm in here. I just came from a meeting with them. I've been trying to do everything I can to get on the right path and, seeking help, no matter, counseling or whatever it may be.
Or if you got out of jail, where would you go?
Back to my father's house until I figure out a halfway house or, maybe mental health or anything. It really just to be on the positive path. I don't know how, the probation and stuff would work. So my father's house until I figured out.
All right, when's the last time you worked?
Last year at Coachman.
Which plant?
103.
Well, Mr. O'Bear, what's your thought here?
I would like to see him placed on a probation. I think there's mental health issues. I think there's substance abuse issues that a probation could help him deal with.
Mr. Truckee, what's your thought?
Mr. Terry's made it clear to me that this was some sort of a cry for help. Discharging this firearm, he knew it was sure to get the attention of the authorities. I suspect he in some way wanted to be arrested that day. because of paranoia and some concerns he has that I think would respond well to treatment that could be monitored by a probation officer.
Whose gun was this?
It was a gun that came from the Cass County Shrine Club. It was one that was won at a turkey shoot a long time ago. It was my uncle's.
But it was just at your dad's house?
Yeah,
What other kind of work have you done other than trailer factory?
well, for the past time being, since I lost my job at the trailer factory because they were getting slow, they had a layoff, and I was a new person. I've been mowing yards, building fences, setting up like subcontracting.
Well, both your lawyer and the prosecutor are asking for probation. I'm gonna put you on a 12-month probation. I'm gonna order 90 days in jail, credit 15. And I'm gonna defer 75 days. I'm hanging some jail over your head. I want you to participate in this probation. You have a suspended driver's license, don't you?
I'm not sure. I haven't been driving just in case. I had
Yeah,
a new
there's no
license.
allegation of driving here, but you've got unpaid fines here from 2022.
Driving without insurance.
Yes,
I thought the 17 days that I did in jail was time served.
there's some you can't wipe out the $125 fees, so there's fees that are left over. Fine is 0. There's a $75 crime victims' rights fee, a $50 state minimum fee, $150 attorney fee, and $480 probation oversight fee. That's all due in 1 year. 125 plus 150 plus 480, 755. I want you to seek mental health treatment and sign a release from community mental health. No drugs and no alcohol, and test as directed. No firearms. Pay all unpaid fines and costs here at 3B District Court. When you get out of jail, I want you to come to the courthouse and check in with the probation department. We'll get you started on this probation. I got 75 days jail hung over your head. This makes me nervous. You had an earlier gun charge. You did complete it. It was reduced from a felony to a misdemeanor. Then you had a felony charge in LaGrange, and you're not allowed to have a gun or bullets. You can't have brass knuckles anyway. And that's a fool's errand to have brass knuckles for somebody that's out on your property with a gun. But that's been seized and that will be destroyed. This also results in the gun being destroyed.
Yes, sir. In that paperwork, it said that there's 2 different descriptions of a bullet. If it's the red, the pheasant shot, and not the Winchester steel shot, is there a possibility if that primer has been struck, if I could keep that as a memento?
Yeah, a spent bullet, I don't care. A memento of what? Getting arrested for reckless use of a firearm?
No, sir.
All right, well, I don't have an objection to you getting a spent shell casing, but it might be a logistically a little hard. Ask your probation officer about it. All right, let me repeat. I gave you 15 days in jail, but I gave 90, credit 15, and I'm hanging 75 days over your head. I want you to not use any drugs or alcohol, take a test as directed. I want you to get it plugged in with community mental health. No guns, no firearms, no assaultive behavior. And sign a release. All right, when you get out of jail, either later this morning or just after lunch, you come up to the probation department and check in, okay?
Yes, sir.
All right, you're good to go. Will somebody pick you up?
If I have to wait till 4 o'clock, it'd be my fastest ride.
All right,
And
well,
if I
then
could- if
when
I
you
could
get out
walk
of
up
jail,
there-
walk up here to the courthouse. If you need a bus
sir.
pass, I can give you one of those.
Thank you very much, sir.
All right, I'll see you in a bit. Thanks.
Thank you.
Okay, I just got to cut in here a minute. First off, good morning, everybody. It's good to have you here. I'm Dan. Welcome to the Courtroom Files Live. First off, I'm just flabbergasted. The guy wants to keep the spent shell as a memento. I'm kind of with the judge on this. A memento of what? Maybe he's hoping to look at it and as a reminder of how he shouldn't act. I don't know, but that's an odd request for sure. I also wanted to point out, and I put this in the chat, that brass knuckles are actually, I looked it up, they're only legal now in 12 states. I'm in Arizona. We're a state where it is legal, though there are certain cities in Arizona that have outlawed them, interestingly. But I find it curious. This is how, the more court I watch to help with this channel, to build this channel for all of you, the more I'm confused by how a lot of our laws work. The statement I'm about to make is not pro or anti-gun, but I find it super interesting that it is easier to get a firearm in most places of the United States now than it is to get a pair of brass knuckles. That just doesn't add up to me. I don't get it. Let me know in the chat what you think, but I'm super confused by that. Why is it so hard to get brass knuckles, but it's fairly easy in most of the country now to get a firearm? A lot of the country now has gone to constitutional carry. You don't even need a permit to carry in a lot of situations. Again, I live in Arizona. We're like the Old West here. Everybody's carrying. And it's one of the more peaceful states, maybe because of that. I don't know. Nobody wants to start anything because everybody's armed. But still, it's confusing to me. Why is it so hard to get brass knuckles, but easier to get a firearm? Let me know what you think in the chat. Anyways, let's get back to Judge.
Mr. Terry. There's Wood. There's Crew. Crazy. We're not doing too bad. I said I thought it would take us till 11.
This cup should be resolved as well. There's just a question of which prosecutor.
Okay.
did.
Jeffrey Hunt wants a prelim, Thorley waiver, Floyd waiver. Crazy for crying and crazy for crying. Crazy.
got a sentencing with your counterpart, right now, Judge.
At 10:30?
Yeah.
All right, what are we gonna do with Ms. Cobb?
The offer is OWI second and, no objection to sobriety court if that's available to her.
Well, I'm certainly, yeah, she was charged, I think as a first.
Judge Fleischer has come online. Let's go ahead and see what's going on in his court this morning.
Come on, I'm going to do it in a heartbeat. No weapons as well, sir. How old are you?
17.
You're 17. What do you do for a living, sir?
Nothing. I don't have a job. I don't have a job.
Are you in school?
Yes.
Are you in high school?
Yes, sir.
Okay. You have to be careful, man. This life is really short, and it's not fun to live in a 6x9 box because of a rash decision that you make. Once you start racking up convictions, and once you start racking up all these charges, your life is really just going to go sideways. You know, everyone looks at your record, you know, from employment, schools, just everyone. And when they see a bunch of stuff on there, it's just not going to help you. This life is hard enough as it is. Life doesn't get easier the older you get. It gets harder. Do you understand?
Yes, sir.
Okay. I'm also ordering you not to consume alcohol or any kind of illegal drugs. If I find that you're smoking marijuana or anything like that, likewise, it's not going to go well for you. I'm telling you now that I'm going to test you. It's going to happen. And if I find that you're using, it's not going to go well for you. Do you understand?
Sir.
I will give you a lawyer today so we can figure out and talk about how to go forward. Do you mind reaching out to the Mac, please?
Yes, Judge.
But I don't want any more foolishness. You understand?
Yes, sir.
Okay. Felicia,
Yes, Judge.
have you got a rip done on this case?
Let me see your honor.
My only concern,
We haven't yet.
yeah, do you mind? My concern is that they live in the same house as the complaining witness, is Mr. Milano.
They do, just based on a brief look into the case, the person I contacted is the complaining
Okay.
father. So I do believe they're different households.
All right, so let's do this. I'll have you talk to the lawyer here momentarily, and then we'll figure out how to go forward. All right, do not leave until I have excused you. Do you understand?
Yes, sir.
Okay, come on.
Right this way.
Right,
This way.
Judge, that was the last one.
Okay,
You get them in person.
I thought he was older than 17.
Go ahead and sign here, reset, please.
That's fine. Thank you. Yeah, I tried to.
We have a suppression hearing? We have a sup-
That's it for now.
Do we have a suppression hearing today? Do we have a suppression hearing today?
Judge, who would that be on?
Say it again?
Who is the hearing on? Who would that be on?
Jose's case?
Who is it, Judge?
Who's he here? No, sir. He's here on a subpoena.
Oh, he's here to deliver evidence.
Yeah.
Sorry.
No problem.
Thank you for everything you do, though.
And it was your too.
Man.
We have one on the 20th, though.
No, his specifically said 311 and it's just.
Okay.
Okay.
Yes.
I think that no one informed the officer, so he came here.
Oh, okay. Makes sense.
I thought we had that, Jose.
All right, well, Judge Fleischer tries to figure out what's going on in his courtroom. Let's see what's going on with Judge Wolf. He's in Cheatham today, Cheatham, Tennessee.
Clark. Good morning.
Just making his way up. Your Honor, I'm still reviewing the discovery in that matter. Request another status date, preferably about 90 days.
All right, your next status date would be, is this your case?
Yes, General State.
General Segis, so that would be, oh, sorry. So what's the next status day that you want to have, General Silvers?
July.
Well, we have July the 8th for me, if it's going to be remaining in front of me.
That day looks fine with me, Judge.
Is that all right? All right, we'll reset, Mr. Clark. Now, this July 8th date will be the final plea day on this case, meaning that if it's not resolved by an agreement on that day, then it'll be assigned a trial date. Once we assign it a trial date, it'll either go to trial under this new system or plead to the indictment and go to sentencing.
Thank you,
Okay?
Judge.
All right, July the 8th. Thank you.
Thank you.
2023 CR 19477, State versus Edgar Harrison.
That's my case, Your Honor. He's present. Would you put that on second call, please?
All right, put it on second call. Thank you. You have the next one as well. 2023 CR 19407, State versus James Dwayne Heath.
That's gonna be for plea today, if you could put it on second call.
All right, second call for plea. 2025 CR 19709, State versus Nathan Heathman. Nathan Heathman. Heathman, you're here to be arraigned on a charge of an indictment charging you with sexual battery. You have the right to an attorney. Do you wish to have a lawyer representative?
Yes, sir.
represent you?
It's Sonny Stevens.
Who?
It's Sonny Stevens.
So have you already retained Ms. Stevens?
Yeah, she's somewhere in the door.
All right, so she has actually been retained to represent you on this case. You know why she's not here?
No.
Okay. All right. We'll deliver a copy of this indictment to you. I assume you want Ms. Stevens to read it over with you. Do you want to read it yourself or do you want to have it read to you in open court?
I'll read myself.
All right, show he's waived the formal reading of the indictment. Is this your case, General Sylvie? You want the July 8th date?
That'd be fine.
Doesn't matter to me. I'm just asking what you want, so.
July. Thank you.
All right, we're going to give you a date for status of July the 8th. You need to deliver a copy of that to your lawyer. On that date, if it's not settled by an agreement, it will be assigned a trial date and you'll either go to trial or plead to the indictment and go to sentencing. Do you understand that?
Yes, sir.
All right, thank you. Twenty 2024 CR 19653, State versus James Jackson.
Judge, I represent Mr. Jackson. If we can just get a status date in July, him as well, for he and I to go over discovery.
You want the July 8th date?
Please, Judge.
July 8th for the last status. Now, Mr. Jackson, I want to make sure you understand, this is the second time this case has been given a status date. So that July 8th date is your final opportunity to resolve this case by an agreement. On that day, if it's not resolved by an agreement, then it will be assigned a trial date and it will go to trial or you'll have to plead to the indictment and go to sentencing. You understand that?
Yes, sir.
All right, we'll see you on July the 8th. Thank you. 2025 CR 19694, State versus David S. Johnson.
Good morning, Your Honor.
Good
That's for arraignment. I have waiver, waive formal reading, enter a plea of not guilty. He has another.
Price will be shown as the attorney.
He also has a court date already of the 18th. It's a probation violation, but we're kind of doing them together. If we could set it on that date, please,
All
sir.
right, we'll set this for March 18th and let you see what you can work out.
Thank
All right,
you.
Thank you. Moving to page 6, 2025 CR 19710, State versus Jonathan Kane Krantz. Grant, you're here to be arraigned on a charge of an indictment charging you with aggravated domestic assault, in violation of the protective order. You have the right to an attorney. Do you wish to have a lawyer?
Yes, sir.
Are you able to hire a lawyer of your own choosing?
No, sir. Mr. Vaughn was my lawyer and General Sessions.
Mr. Vaughn, I know that you were representing him below. Was there an determination of his indigent status at that point?
There was Judge Maxey determined it.
Then I will appoint a public defender at this level as well.
We'll wait for more meeting.
All right. July the 8th for status, and we will determine whether at that point in time it needs to have a trial date assigned. Understand that on that day, if you and your lawyer work out an agreement, I'll accept it. Beyond that day, you may have a trial date and you'll have to go to trial or plead to the indictment.
Yes,
okay. All right, thank you. General Sylvie. Vaughn.
Yes.
2024 CR 19649, State versus Timothy Joseph Lewis. Public defender.
Judge, I represent Mr. Lewis. We could get status date in July. More you wrote. This, I believe this is the 10th.
All right. You want a final opportunity to try to resolve this case or set it for trial? We'll set you for July the 8th, and that'll be the final plea day, which means on that day, Mr. Lewis, we will either allow you to settle it by an agreement or set you for trial, and you'll go to trial or plead to the indictment and go to sentencing.
I didn't hear the date. I'm sorry.
Mr. Vaughn's going to explain it to you. We're going to give you one last chance to try to resolve your case by an agreement. That means on July the 8th, you will either have to work out an agreement to settle your case. I'm not telling you to, but on that day, I'm going to assign you a trial date if it's not settled. Once I assign a trial date, you'll have to go to trial or you have to plead to the indictment and go to sentencing on every count of the indictment. Okay? All right. Thank you.
Thank you.
2024 CR 19657, State versus Mark Lynn Majors. It's also a public defender.
Judge, this is Mr. Richter's case. And so it says he needs a trial date on the DUI prosecutor's date. It's my understanding that General Stevens has even months.
Okay.
But it appears that he needs a date, a status date on it.
Do we have General Stevens' trial dates?
Just an April. What's the date in April?
You have do you
I just have a text that says for other DUI status, please get a status date on lawless return vote.
So April 15th for
April
status.
15th. That's not a trial date, that's a status date, right?
Right.
All right, April 15th. Judge Wallace will assign a trial date on that date. Moving to page 7, 2023 CR 19475, State versus Ruben Cabrera Medina. Ms. Fordyce.
Yes, present, and there's a translator here. If we could put it on second call, but it may need a new date.
Let's put it on second call.
Thank you.
2023 CR 19397, State versus Robert L. Moss. Ms. Fordyce.
Yes, I'm really concerned because I haven't heard from him or seen him. I was just doing some text and, I haven't heard from him. Can I put it on second call and see if I
I'll
can
give
round
you an
him up?
opportunity to see if you can find him.
You,
You have the next, oh, I'm sorry, that was the same case. There's several of them. All right, 2025 CR 19705, State versus Zachary Lee Mowell, that's, transport, so he'll be in custody, I think. All right, we'll bring him up and we'll deal with him. 2020 CR 18932, State versus Dustin Lee Parker.
Judge, that is another one of Mr. Richter's cases. There's a forensic evaluation in process. For an intellectual disability expert, if we can put that on Judge Wallace's April EOP date.
April 29th. 2023 CR 19524, State versus Lisa Pressgrove, Public Defender.
Judge, is also Mr. Richter's. His notes indicate that she has COVID and sent Mr. Richter.
Who has COVID?
Mr. Pressgrove.
All right, she has COVID.
And sent a picture to Mr. Richter. And it appears to be a confirmed positive test. Just needs a trial.
Just like a pregnancy test, you can take a picture of it and.
I think maybe so, Judge.
All right, so what do you want to do with it?
Mr. Richter indicates he just needs a trial. I don't know if he means.
Who's the prosecutor? All right, General, not me, is the prosecutor. All right, Mr. Flanagan wanted his matters, he's in trial in Charlotte. He asked that his cases be set for the 18th to allow it, so I'm just gonna move this to the 18th and we'll deal with it on that day. March 18th, we'll figure out a trial, how to handle it that day. Page 10. Carl Lee Tibble in the courtroom. All right, we'll set that one for the 18th. That is actually Mr. Flanagan's. All right. 2025 CR 19698, State versus Donald Edward Rosenbaum. Rosenbaum, you're here to be arraigned on an indictment charging you with driving under the influence, fifth offense, violation of the motor vehicle ignition interlock device, financial responsibility law violation, and registration law. You have the right to an attorney. Do you wish to have a lawyer?
Yes, sir.
Are you planning on hiring a lawyer?
No, sir.
Why not?
I can't afford it right now.
Raise your right hand. Let's place you under oath. We're going to have you fill out an affidavit of your income and expenses for me to determine whether you're qualified to have a lawyer appointed for you. So when you sign this, when you fill this out and sign it, you're signing it under oath, so it has to be accurate or you're committing perjury. You
Okay.
understand that?
All right. As of probably I think 2 days ago, they basically went ahead and terminated me from work. So
So you're not working anywhere?
no, sir.
All right, well, all you got to do is fill out this form, sign it, and let me look at it, and then I'll come back to you.
Okay.
I'll put you on the second call. Thank you.
Oh,
They're going to give you a form, fill out.
Okay.
So you need to have a seat, fill it out completely, and then we'll come back to it. On page 9, 2025 CR 19680, State versus Austin Gordon Simpkins.
Mr. Simpkins. I spoke with General Willoughby. On February the 4th, Judge Turnbow recused himself from this case. So we were going to be asking for another status date on this matter. And I have a proposed agreed order that would waive my client's appearance for today's date.
Proposed agreed order that you've seen.
I do not,
I thought this is one.
sorry. It has actually ink on it.
This order just simply waives the appearance of the defendant and shows that it will be reset for another status day. It doesn't provide a status day. I'll go ahead and sign it, but
Yes, sir.
we'll set you for July the 8th.
Yes, Your Honor.
All right.
This is obviously not a co-defendant, but it tracks along with Shannon Elliott. So you, Your Honor, took that plea.
All right. So is the Elliott case on the July 8th already?
No, Elliott has already pled, but it's the same scenario.
Okay. So do you want to set it for the July 8th?
Yes, Your Honor.
All right. We are resetting it for July 8th, and that will be the final plea date. And at that point, we'll either sign you a trial date or you'll go to trial or plead to the indictment. Thank you.
Thank you.
Next case is 2024 CR 19661 State versus Joseph D. Singleton. Mr. Flanagan is the attorney, so we requested that he has requested we set his cases for March 18th, so we'll set it for March 18th. 2024 CR 19652 State versus Jonathan Smith. All right. Thank you, Ms. Fordyce. 2024 CR 19663 State versus Zachary C. Smith.
Judge, we represent Mr. Smith in this matter. Came to our attention that we've got a conflict. We tried to withdraw in February. Nope. Hold on. Let me second call, can I second call him?
All right, I'll come back to Mr. Smith, and public defender needs to do some checking on something. 2023 CR 19431 State versus Wesley Sovine. That is also Mr. Flanagan's case. We will reset it for the 18th for the final plea. And that will also be the date for the motion to revoke bond.
Just an FYI, I've got eyes on obviously Judge Wolf here, but also on Judge Fleischer, Judge Meineke, and Judge McBurney, and Judge Slavin. So a few different courts that I'm monitoring right now, but honestly, everybody's very quiet. Judge Fleischer actually just walked out of the courtroom out of boredom, I think, a little while ago. So we'll stick with Judge Wolf for now.
The conditional forfeiture of the bond in the amount of $10,000. Sire Fleischer of the bonding company set the final forfeiture for that date in September.
I don't know if the clerk needs to know, but that will be general savings.
Okay. Well, when we get them here, we'll set it on that day. And in the interim, I'm just setting a date for the final forfeiture, which is, let's say, September the 19th.
I think they started putting the prosecutor's name in their system, so that's free time.
All right. And the new bond will be $25,000, capious for the defendant's arrest. Twenty 2024 CR 19596 State versus Brittany Danielle Trice.
Judge.
They work for it. All right, let's put it on March 18th. It's her motion, if I understand correctly, that to change her program due to insurance issues. We'll put it on March 18th if she wants to pursue it. 2024 CR 19623 State versus Gage Waddell. I assume you have another agreed order.
Yes.
You sign off on this one? Okay, and that was to move it when July.
Back to May. I don't remember the specific date off the top of my head.
All right, I believe it was May 13th. 2024 CR 19557 State versus William Hunter Washington. Ms. Fordyce.
On Mr. Washington, we're gonna set that subject to your honor's approval to July 8th for restitution. If he's done that, then the case will be disposed of.
All right. Final plea day will be July 8th. Thank you.
Thank you, your honor. July the 8th.
Moving to page 11, 2025 CR 19702, State versus Jonathan Williams. Jonathan Williams for arraignment. A conditional forfeiture of the bond in the amount of $5,000, K position for the defendant.
For the clerks, that'll be good.
All right, this will be General Segi's case. Official, the bonding company set the final forfeiture on September 19th. Cape is for the defendant for failure to appear. And new bond will be $25,000. Two 2017 CR 18165 State versus Christina Meadows Young. So Arnold, you signed off on this motion, is that correct?
That's correct, Your Honor. And General Crouch and I have discussed it. His position is the same as mine, Your Honor. We'd like to give this Meadows Young whatever we can.
Right, I have signed the order.
Thank you, sir. Thank you so much.
All the remaining cases are on the docket are at large, is that correct? Mr. Vaughn?
I can address Mr. Smith. I got confused with the case I have next week. That Mr. Zachary Smith just needs the status date in July.
Zachary Smith.
Yes, Judge.
All right, going back to page 9, State versus Zachary Smith. That case will be set for final plea day for July the 8th. Mr. Smith, that'll be your last opportunity to settle your case by an agreement on that day. If you do not have an agreement to resolve your case, I will assign a trial date and you will be required to go to trial or plead to the indictment and go to sentencing.
I got a question. When they assigned me Timothy Richter at first, and then I was told that there was a confidential informant on my case that something they've been telling me for a couple months that they wasn't gonna be my lawyer.
That's right. He's right.
Yeah.
I got confused with Justin Wine next week, but yes, we have also had a conflict.
I haven't seen a motion or anything yet, so I was just.
All right. I'm going to relieve the public defender's office and I'm going to appoint Mr. Scott Saul to represent you on this case. I assume are you working anywhere?
Yeah, yes, sir.
Well, I'm not sure you qualify to have an appointed counsel. Raise your right hand.
Yes, ma'am.
I'm going to have you fill out an affidavit of indigency for me to determine whether or not you qualify to have an appointed counsel, because otherwise, if you're employed, you may be required to hire your own lawyer. The only time that you're entitled to have an attorney appointed is if you are in fact indigent and unable to afford one. So I will give you an opportunity to demonstrate to me that you're unable to hire your own lawyer, but you're going to have to fill this out. You'll be signing it under oath to make sure it's accurate. Take that form from the clerk and fill it out, and we'll come back to you later in the day. Curtis Day.
General Crouch is, I believe, ready to trial.
And who represents, this term represents the defendant, right? No, I'm sorry, Mark Asherson. Haven't heard anything from Mr. Asherson, but as far as I know, it's set for trial and it is a go.
Saw both my boss and Mr. Atchison yesterday, and it's my understanding they're both ready to go.
All right, it is a go for next week. All right. Anybody have a case that you understood you were supposed to be here, and this morning, and you have not had your case called, come up to the podium. Good morning, Mr.
Joey Fuson on behalf of Mr. Roy Mayo, Your Honor. He's a jail case, and I didn't hear him called. It was set for a status date today. It's an older.
Have him on the bring up, I'm not sure, but I show he is on page 6 and 7.
Your Honor, this is an older case. I was just assigned to this case at the end of last year. I've exchanged discovery and talked to General Willoughby. I'd be asking the court today for one more status date. I
can give you one more status date, that July 8th date, and on that day, if it's not resolved, I'll have to assign a trial date, and he'll then be required to go to trial or plead to the indictment.
That should be plenty of time,
Is
Judge.
this your case, General?
It is, Your Honor.
All right. July the 8th.
Thank you, Judge.
All right. What's your name?
Colin Williams.
Called Miller.
Colin Williams.
All right, your case was bound over from the grand jury, but the grand jury did not have an opportunity to reconsider the charges against you. So it will go to the May term of the grand jury, and you need to check and be here on May the 13th.
May 13th.
Okay?
All right. Will that be at 9 o'clock?
9 o'clock.
Okay, thank you.
All right. Anybody else that understood you were supposed to be here, come up. What's your name?
Joseph Singleton. Mike Flanagan's my lawyer, and
Right, Mr. Flanagan is in a trial in Charlotte, and for that reason, he requested that all of his cases be moved to next Tuesday, the 18th.
Okay.
So we're gonna have you, we've moved your case to the 18th. Just stay in touch with your lawyer and be back here next Tuesday.
yes,
okay?
sir. Thank you. Thank you.
Crystal Gail Kramer. Remember, your case was called, but I think we put it on the second call because you were running late.
Yes.
And you're here to be arraigned on an indictment charging you with simple possession of a Schedule I drug, simple possession of a Schedule V drug, and tampering with evidence. You have the right to an attorney. Do you wish to have a lawyer represent you,
Yes.
a public defender?
Yes.
Are you able to hire a lawyer of your own choosing? Well, let's raise your right hand. Let's place you under oath. I need you to fill out an affidavit to show me what your income and expenses are for me to determine whether or not you qualify to have an attorney appointed. They're going to give you a form. If you'll fill that out, we'll come back. Okay. You're signing it under oath, so make sure. I'm going to give you that. Anybody else in the courtroom that you understood your case was to be called this morning and I've not called it? All right, then we have the next step will be to bring up those inmates that need to be brought up. You guys talking about anything I need to be involved in?
Yeah, absolutely not.
It's nice to know. I just wanted to make sure. We'll stand in recess until we can bring up the inmates that are being requested to be brought back. Go ahead and bring them up.
Okay, well, Judge Wolf goes to recess. We thought we'd show you what's going on in Judge Fleischer's court. He's held this position for a good 15 minutes now, just staring at his monitor in boredom. Somebody really needs to get him an Xbox on the bench since he likes to play Fortnite and stuff, so he can better pass his time during these these down moments. So I'm going to go ahead and switch us over to Judge McBurney. He has a defendant in front of him now. If you haven't listened to Judge McBurney before, warning, he sounds a little bit booming on his microphone. There's nothing we can do about that except turn down the volume a little bit, but his court is entertaining to watch, so let's go ahead and spend a few minutes there.
On reconsideration if needed, or
Okay.
If you have more questions.
Got it.
Let's see. So, Your Honor, again, he has one sibling on his mom's side that he has assisted with, and on his dad's side, he has another sister. His father's a truck driver. He was attending, I believe, Redan Middle School as late as November. And due to some transitional things, I think that is about the last time that he attended. Of course, he got arrested on these charges, and now he's here. Let's see, I believe the prior charges, Your Honor, from what I understand, the one from Rockdale is about a weapon at school, but it was not a gun, it was a pocket knife, Your Honor. And with regards to this incident, Your Honor, I would like to say this on his behalf since we've already spoken about it. Your Honor, a stranger, a 50-year-old man, snatches something away from him, and he is with 5 other people. That's a very bold gesture. It's a little frightening. He's 15, they're 14. I'm sure they didn't quite know what to make of it. In the video, you can see the attempt to take it back without any violence or anything at first. And I can't speculate what was going on with this man, but he was not afraid. So I think from there is how it escalated, Your Honor. And despite the state's contention that he was shot twice, he was not. It was one shot. And also, Your Honor, it's also corroborated in the search warrant by Mr. Jackson that you can see the alleged victim grab the phone from my client. So,
So the something is a phone. You first said that a stranger snatches something from your client, but the something is
it
a
is
phone.
a phone, yes.
Okay.
Mhm. It is a phone, Your Honor.
Okay.
So with that, Your Honor, again, he's 15. He's not, I don't think he usually carries a gun. And so again, he didn't produce his own gun. I think, you know, the circumstances show they were trying to defend himself and his property. So with that, Your Honor, I would ask that you provide him with the bond. I don't think he is a terrorist of the streets, or he's going to be problematic as far as returning to this court. As far as I understand, he's always appeared for court, Your Honor. And I think that this court can customize any type of necessary rules to ensure that he returns to court, including the ankle bracelet sponsored by DJJ if necessary. His parents are having somewhat of a difficult financial time. Again, that's why I said his mother was in a transitional area, and he would be going to go live with his father, who has other children as well. And so for that, Your Honor, and of course he is indigent, which is why he has indigent counsel. I asked for a low bond as well, Your Honor. I'm asking for a bond not to exceed $5,000. Of course, he could stay away from other co-defendants, will be required to stay away from other co-defendants. No guns or weapons, Your Honor. And that is the defendant's request.
Okay. I know Mr. Smith couldn't be here, one, because he had a conflict, two, he didn't know, because you didn't know we'd be talking about bond. So you may need to do this research after we break for the day. But you mentioned he's a trucker. And that's a great way to make money, but it also can lead to not being around a lot. And so I'm curious if you could find out from him what his supervision capacity is. Is he on the road for a few days at a time? Is he gone overnight? What is his ability going to be? You mentioned that you thought having Mr. Horn with dad rather than mom would be a little more stable and maybe a firmer hand. But if it is an absent or a distant hand, it's just something to know and understand. So if you could check with him and then let me know, that would be great.
Absolutely.
Okay. Ms. Dilligard.
Yes, Judge. So my argument is very similar to the previous defendant. However, this defendant is not similarly situated. This is the defendant that actually pulled the trigger. I think counsel is correct. He was shot once, but he has 2 bullet wounds, one to his hand, one to his inner thigh.
Okay.
I do think that I'm reading the reports, and that's where I'm getting my factual basis from. They are conflicting. It seems as though I don't know if the phone was snatched, and the video will clarify all of this once I can retrieve it and send it to Your Honor.
So you have not seen the video?
I have not seen the video.
Oh, I thought when you corrected Mr. Francis, that was because you've seen the video.
No, Judge. I'm reading from reports from both our intake team and also reports from MARTA police.
Got it.
And those two differ, so I will put that.
Then we all ought to see the video.
We all ought to see the video. However, I do want to state that the report does say that that victim remained seated on the bench. The report says he was seated at the entire time. He was shot while he was seated. And so I don't think that at that point there was any danger to either of the defendants who were in a group, and it was just the victim solely alone. And I also don't think that even if he did take a phone from them, that warranted being shot. And so that is my stance on the facts. I do want to point out to the court that this defendant, as counsel has mentioned, was arrested back in January 2024 for entering auto and obstruction. Then this incident in November 26th of 2024. And then I also see a recent arrest on February 3rd of 2025 for shoplifting. And he also had a firearm during that incident as well.
How would that work? He's been in custody since November.
He was not picked up at that time, Judge. He fled.
Oh.
The others were detained at that time, and he fled on the train, I believe.
Got it. So 5 of the 6 were detained.
Yes.
That's where I got the number 5. It mentioned, I didn't realize that the one that didn't get scooped up at that point was Mr. Horn. Okay. Was there a warrant for him such that when the shoplifting happened, he went into custody for good?
He was actually in custody when the officers contacted me and said that they thought that he was in custody and that they had warrants. So then, once that was determined, they went out there and served him with the armed robbery.
Got it. He was in custody in connection with the shoplifting allegations.
Correct.
And people connected the dots to say, there's a young man being held in connection with shoplifting with a weapon. And they said, oh, that's the guy for whom we've got these more serious warrants. And here we are.
That's correct.
Okay, got it. So, Ms. Hill, how long has Mr. Horn been at the YDC? Since, was it January or February?
February.
February, okay.
I believe it's correct, Your Honor. He was indicted fairly quickly once he got there.
Okay, got it. Anything you want to add, Ms. Hill?
No, Your Honor, I believe nothing further.
You filed an immunity motion. We'll get that scheduled. I want to make sure you get discovery before then, just so that you aren't surprised when the video is played, that kind of thing, unless you've already seen the video.
I've watched the video several times.
Oh, how did you get the video?
I got discovery yesterday, maybe?
Oh, okay. So the state's already provided discovery?
Yes.
Excellent. Okay. So you, among all of us, you're the only one who's seen the video.
Yes. So.
Did you write your immunity motion after you saw the video or before?
After.
Okay, great. Well, we'll get that teed up soon then, because you do have discovery, and we ought to get that closure. Either we're done, if it's granted, or at least we're moving forward, and you know how that one's playing out. Have have you filed leave so we know when you're not around as we try to schedule this?
Yes, I believe my leave was filed a couple weeks ago. Should have been.
Yeah.
I'll double check.
No, I see it. Well,
Okay.
assuming this is yours, let's see. Okay, yeah, that's great. And it's just individual days here and there as opposed to big spans.
The only big span is the week of the 25th. I'll
Right.
be out for.
I see that, and we will not bother you then.
Okay.
Okay, great. Okay. So Mr. Horn, I'm gonna watch this video that your lawyer has already watched. And then I will either set a bond that is a number that I think is reasonable. The bond conditions will include that well, it's all pursuant to DJJ supervision, but you have an ankle monitor, and you would be required to go to school once you're eligible to go to school. No contact with any of the co-defendants, no guns in the house or around you in any way. And there'd be a curfew so that if you're not at school or some other organized event that Ms. Singleton or others have approved, you're kind of stuck at home while we're working through all this, okay?
Okay.
Any questions about any of that?
No.
Okay. Ms. Hill, if bond is set and made in the very, very near future, Mr. Smith is ready to take Mr. Horn in? Like that transition is already happened, or it can happen?
No, it will happen. He's going to his father.
Got it.
I spoke to him about that. Yeah, I think they're only concerned about the amount and if they're going to be able to.
Well, I get that. And if it's $100,000 bond, it might as well be $1 billion bond. Okay. No, that part I get. I just wasn't, you were helping me understand that mom's going to be working through her own challenges. And so dad is ready as of whenever bond is granted and posted to take in his son.
Yes.
So I'll be getting from Ms. Dilligard the video. You will be getting to me and Ms. Dilligard what information you get from Mr. Smith about how present he can be given his line of work in the household. And if he can't be, if his answer is, I'm out 3 days a week, I'm on the road, who is it who is around? Because it sounds like there are other kids in the household. And so maybe there's someone co-parenting or who knows what, but I'd need to be comfortable if Mr. Smith can't be there for big chunks of time that someone else is.
Okay.
Okay.
Is that something the court would like me to remain here to deliver that report or?
Email's fine. Yep, just email me and Ms. Nelson. And if you don't have my email address, just send it to Ms. Nelson, but it's fine to send it to me as long as you copy Ms. Dilligard.
Okay.
Okay, great. Mr. Horn, you have any questions about anything we talked about?
No.
Okay, we're done. And Ms. Hill, I promise we won't do other surprise motions like this. I didn't mean to catch you off guard on this. I just figured since we were talking bond, we'd cover everyone who was here.
Okay, you're looking live at Judge Fleischer's court where he's just abandoned his chair now. He's had such a slow morning there. Oh, no, he's coming back. But they had a person that they were trying to bring out and actually try to do business for one of the few times today, and that person covered themselves in feces in protest, so that didn't go through. But let's go over to Judge Middleton because he's got some stuff going on. So let's visit with him for a little bit.
All right, I thought you were the full-time Leonidas attorney, and but would you give her that?
I've visited the scene many, many times here.
All right, well, let's see here. Let's find a date to put this. We're gonna need to put it out a little bit. I would tell you, you can watch our sobriety court on the YouTube channel, but we don't live stream those. They're between me and my defendants and the staff.
Ms. Cup's done more AA meetings than anybody I've ever met, and I think she's really gonna fit well with the sobriety court program. That's.
You need to meet more people. Eddie Mackay's been going to AA meetings for 50 years.
I should say per day. Right.
Oh, per day, all right.
I've seen a 50-year chip and it's pretty impressive.
Are you okay for Wednesday, April 10th Wednesday, April 9th at 10:30?
That appears good. What was the time again?
10:30. All right, I want you to take these two things out to the counter. They may want you to go down and see the probation staff to get started on this. We have our staffing this afternoon. And Deborah, I guess before we do the sentence, we'll figure out whether we're gonna use the numbers for ORV. The law says you're supposed to charge the narrowest crime that fits the facts.
I looked at the statute. Well, this was charged, like reviewed and charged by our chief assistant. And because we have that ORV permit where you can drive them on the roadways, and this was on the roadway, I think it fits more as a motor vehicle. It was being used as a motor vehicle versus being.
Because an ORV violation doesn't have to be on the public roadway. It could be on the back 40 and you flip over and injure somebody. So this is on the public roadway, so they charge it as operating a vehicle.
Yeah, I have not specifically asked Chief Assistant Robert, but that was.
That was my view of it.
All right, yeah, this is on a public roadway rather than, the other statute does not require. I suppose it could have been charged as that, but this, I'm not sure what that is point wise, and so we'll just treat it as operating while intoxicated, second offense in a motor vehicle on a public roadway. Now, when this hits your driving record, it's going to be a little confusing because the Secretary of State doesn't know about your Vicksburg conviction. Theoretically, what would happen is your driving privileges would be revoked. And the only way you'd be able to get a driver's license is by being in sobriety court. After 45 days, you could be eligible for a restricted license to get back and forth to work and treatment and school, other limited purposes with an interlock. Most of the people in our program are have an interlock. And there are a number of women in there that are doing quite well in the program right now. You seem like a good fit, but I'm not clear what the status of your driver's license is. It says canceled. So we'll have to sort some of that out as we go through to do the sentence. But the sentence is Wednesday, April 9th, 2025 at 10:30. Sobriety court. I had another guy this morning that looked like a real good fit for sobriety court, but he lives in Indiana. So I don't think he's gonna fit. All right. Mr. Truckee, if you take her out to the counter, they may want to send her down to see Autumn before she goes. Do you have any questions? All right, you're good to go.
Thank you, Your Honor.
No problem.
I don't thank you for that.
Keeping us safe.
I was struggling with that case yesterday where the guy hit the covered bridge. Gary and I were both trying to figure out which way he was going and restitution. Maybe they'll just sue his insurance carrier, but I do not believe that the guy drove all the way from there to Vicksburg without realizing that he lost his cap, but it was what it was. All right,
Yeah.
I'll
I had-
close the live feed
I
here.
talked to Don from the road commission around the time that
Okay, we're going to go over to a different judge from what we've done on the channel in the past. This is Sheila Johnson, I just tuned into what she's doing, but it looks like she's talking with potential jurors. It looks like we're looking at jury selection, so let's check that out.
Mr. Warren and Mr. Parade. Okay. Because the person who has the burden of proving this case is the prosecution. I read you that instruction that said presumption of innocence, that the person is presumed innocent until the prosecutor proves each element of the crime beyond a reasonable doubt. So, if you heard the evidence and you're thinking about what the court's going to tell you the elements are, and you thought, yeah, court told me, let's just say, for example, there's 4 elements that she has to prove. I got number 1, number 2, I got number 4. I'm not sure about number 3, and she didn't convince me on number 3. Your gut instinct is saying, but I bet he did it. What would your verdict be, Miss Manlin? Right, you're real good now. Mr. Lewis, what would your verdict be? Anybody feel any differently? Shaking your head, no, Mr. Ward, you agree with that? Because the prosecutor has to prove each element beyond a reasonable doubt. It's a heavy burden. Does anybody have a problem with her carrying that burden? It's heavy. Other than her, anybody else have an issue? It's heavy. And your job is to see if she's carried it well. So I like to think of the presumption of innocence as being this cloak, this robe I got on. I call it the cloak of innocence. I should copyright that. But it is like this cloak. So as you go out through this whole trial, this gentleman here is considered not guilty, no matter what you hear. You can keep it in your mind, but you don't make that determination until you get to the bench. You start talking. Anybody think they could keep an open mind like that? Keep a note of what you hear. Keep it open till you hear it all. Can you do that? So this is the cloak of innocence, right? Her job is to take it off. So you hear all of the evidence and you say to yourself, this is what she did. What does your verdict have to be? Anybody? Does anybody disagree? Because the cloak of innocence is still there. That means she did not prove every element of the charge to your satisfaction beyond a reasonable doubt. She might get it down some more. What if she has this arm on? Verdict? Good. She got to get this arm out. She got to get it all the way unzipped. She got to get the other arm out. It's got to drop to the ground. And you've got to be convinced of that beyond a reasonable doubt. Even if you look at him and you say, I don't like him. You don't have to like him, but he still has a presumption of innocence. He could get on your nerves. Would you still be able to find him not guilty, ladies and gentlemen, if she didn't get this cloak of innocence all the way up? What do you say, Mr. Lewis? Could you do that? Could you do that, Miss Manley? Could you find him not guilty, Mr. Perez? What about you, Mr. Watch? Miss Winchester? Mr. Lapeer? Miss Robin? Let's say you like him. He presents well. He seems like a nice guy. She hits every element on the money as far as you're concerned. Would you be able to convict him and give a verdict for the prosecution of guilty if she's taking this robe off? Could you do that, Mr. Lewis? Miss Manley? Mr. Perez? The work. Miss Winchester? Mr. Lapeer? Mr. Robin? Now, you're going to hear from some police witnesses today, potentially. Anybody have any bad experience with the police? Let's hear about it, Mr. Robinson. We'll come to you. Go ahead, Mr. Robinson. What was the situation?
There's been a few of them
Yeah, that's fair.
that got arrested when I was 17. Started casual show. Oh,
It all went away.
that's yeah. Court. I don't have to be a lawyer, but I to give him a charge.
So how do you feel about police witnesses then?
No, I don't know. Perpetrator at the time, they didn't really come in and testify.
Okay.
They ended up having to report without loading charges.
Okay.
And again, when I was 20 something, so we could go back so where there weren't cameras. Better.
Well, do you think all police officers are likely to lie and trump charges up on somebody? Do you think that there could be some that, we could easily rely on to do their job and to tell the truth? So would you be able to judge a police officer just like you would anybody else that you heard from and decide if you believe they're telling the truth or not?
Right.
So you wouldn't discard their testimony simply because they're the police? Okay, you keep a little bit of an open mind. And what would you do and how would you decide whether you thought you believed them?
Litmus test, right? How would you know?
Well,
Trust that they present the right fact.
Well, you might look at it in terms of, does what they say make sense? How does it fit with all the other evidence that you might have heard? Those are the things that we're going to tell you to use in order to make that determination. Let's hear about your situation, Miss Winchester. You said it was kind of bad.
Also had a,
Few run-ins, yeah.
not like me personally, but like family.
Okay, tell us a little bit about it, how you think about police because of it.
Overall, we're all, everyone's capable. So I wouldn't judge it just because they're.
Good. And by the same token, conversely, anybody judge a police officer and believe them because they're a police officer? Simply because they're the police. So they're sworn to uphold the law, protect, serve. If he or she says it, it must be the truth. Would you believe that, Mr. Lewis? So you would never think that they might lie or be mistaken as to what they saw. Okay. But do you know anybody that has never lied or been mistaken?
Right.
Do you know anyone who has never lied or been mistaken? So why would you think the police would be any different? They're human.
They just want to say. So I mean, I never had any problems like that.
So you would simply believe them just because they said it? Okay. What about you? Mr. Perez, how do you feel about a police witness? Would you judge them any differently because they're police?
Somehow, yes.
Somehow, how?
Their job is exposing them to many situations, and their history might be different. So probably knowing a little bit of the background of that person can help us understand how their service life speak
Okay.
and understanding them how thinking themselves.
Very good.
And, yeah, starting.
All right. So if they told you something, you think they would be more helpful to you because of their training and experience that you might really believe what they're saying is accurate.
So if they have more exposure to certain situations.
Okay, well, what if I told you the facts came out that the police officer didn't have a clear view of it? And somebody else was standing right there and said something different. Would you believe the police because he was there and more trained? Or would you take into consideration that he couldn't see it well, and somebody else saw it better? How would you reconcile that?
Well, you guys explained a few moments ago, be clear about what is being told here, and the evidence presented regardless of the person that is being accused. Use the same principle with the policeman sent and showed here.
Judge Wolf has returned to the bench, so we're going to go ahead and go to him. He's doing his in custody clients now.
Joe Camden. Okay. Thank you, Your Honor.
Good.
Thank you. Case number 10, docket number 19390, Amy Willis.
On page 11 of our document. Mr. Locker?
Yes, Your Honor. I think what's on the docket is a motion asking his bond be reinstated. Judge Lockhart Mash denied it previously. I refiled the motion and would like an opportunity to be heard on that.
Judge Locker Mash has heard the same motion and denied it, and you refiled it. And what basis is there for me to go behind what Judge Locker Mash has done?
Judge Lockhart Mash in court stated the defendant did not appear that day. And I advised the court that I was here that date and saw him. He came in late, but he was here. Mr. Vaughn saw him here also. And just based on the judge's mistake, I know it was an honest mistake, she thought he didn't show. But he was here.
All right, if you want to have it heard, we'll hear it.
Yes, Your Honor. Call Mr. Willis as the first witness.
All right, Mr. Willis, if you'll raise your right hand. Let's see.
Very good. State your full name.
Tanyan Edward Willis.
Mr. Willis, do you recall your bond being revoked back this past year? And on the date that your attorney filed to withdraw your case, were you in court that day?
I was. The date was November 12th, 2024.
Did you come in late?
I appeared a little bit after the 10 o'clock hour. Yes, I was late.
And prior to that date, did you both call and text your attorney at that time?
Yes, I did. I also made the deputy clerk, Miss Abby, aware on the morning of court that I was still coming and arriving. Yes,
So you did stay in contact with your attorney,
I did.
or attempted to, and you did show up that day.
Did.
That's all the questions I have.
Mr. Willis, we've done this before, but your attorney showed up that day and said he had very limited contact with you. Do you remember that correctly? Or were you even here?
Yeah, I was here. And I remember my attorney saying, court records will show this. He stated that he received calls from me and he did not answer his phone because he did not know the number.
Well, I don't remember that, but were you here when your lawyer said he had no contact with you, or was that when you were late?
I was, when I appeared, the judge was on recess. My lawyer was sitting up there, I don't want to point, but he was sitting in that seat that the woman with the pink shirt is in. I was sitting down when court adjourned and got back in session, we had our hearing and we were present shoulder to shoulder in front of the judge at the time.
But when did your bond get revoked
That day.
and why?
Judge Locker's words were failure to stay in contact with my attorney.
And you think that's not true?
That is not true.
And then, but he announced he wasn't ready for trial because he couldn't converse with you.
His words again, I quote him, court records will show this. He said his reason for wanting to come off my case was failure to prepare for trial. At the time, I was ignorant to this, but my defense to him was, under attorney-client privilege. So like,
I don't need you to talk about that stuff.
no, I'm not.
Okay.
This is relevant.
I just want to make sure.
It's relevant because he filed to come off my case for failure to prepare for trial. But me being a client in the case, it was to my knowledge that I don't have to prepare a defense.
You said you're ignorant to this.
No, I was ignorant, meaning I've been doing this I did not know. And I've been doing case law study and I've been studying the law.
Okay.
So when me and Mr. Richards were conversing, I can't tell you the attorney-client privilege, but the way I wanted to defend my case was I didn't want to do certain things. So him saying I failed to prepare for trial was not saying I failed to contact him. The one are not the same.
I understand what you're saying, but for you to say you're ignorant to this process, you have 6 prior convictions for felony. So you're not ignorant to the criminal justice system, are you?
I've never been to trial.
Never been to trial?
Yes.
Okay. I don't have any other questions.
Mr. Locker?
Your name is Tannen Willis, is that correct?
Tannen Willis, that is correct.
And Mr. Richards said he had received calls and texts from a T. Willis, but he didn't know who that was. And are you T. Willis?
I am.
Nothing further going.
Thank you. You may step down. You have any other witnesses?
Your Honor, in the interest of judicial autonomy, I would like to testify. It's allowed in the rules.
It's a first for me. I don't know.
Oh, why not? There's a lot of questions I've been wanting to ask Mr. Lockhart for a while. Mr. Lockhart, can you step around, please? I think under the present rules, I'm not allowed to, and when I started practicing law, an officer of the court was allowed to testify without having to take an oath. I think that has since been set aside, and that the rule is now, even though you're an officer of the court, you will be required to submit to an oath. So if you will raise your right hand.
Yes, sir. Yes, I do.
You have a seat in the witness stand. Mr. Vaughn may have some questions after you testify. So.
Careful at the chair.
Watch the chair there. It turns over backwards. Sometimes.
I was just trying to help you out. Like, what do you want to say? I figured I should ask you a question so you weren't.
Yeah,
Go ahead.
the reason I filed this motion, I talked to Mr. Richards, the attorney, and he acknowledged he'd received calls and texts from a T. Willis, but he didn't know who that was. And I just felt like something needed to be filed. And I was here. I saw Mr. Willis here in court that day. Now, I'm not going to call him, but Mr. Vaughn saw him here that day too.
I guess we could take judicial notice. Everybody said yes.
We'll take judicial notice that Mr. Vaughn nodded his head in an affirmative manner. So.
Mr. Richter did too. I want him to ride this ride. I guess my question is, you think his bond was revoked and he wasn't at fault? Is that basically what you're saying?
Let me state this. The docket entry shows that the motion to withdraw was filed by S.S. Richards. It was set for November the 12th, 2024. On November the 12th of 2024, motion granted, bond revoked due to no contact with attorney. And that was basically.
I know that was.
So to answer your question, yes, I do think that the client attempted to contact the attorney. He called and sent text.
It's technically, this is hearsay, but screw it. I mean, what did Mr. Richards say that the only reason he wasn't responding was because he didn't know who was texting him?
He told me he did not know who T. Willis was, and he did not answer or respond to the text.
But he knew that Tanyan Willis had, I'm assuming, paid him to represent him.
I assume. I don't know that. I just asked him because it really concerned me when I saw this happen in court. And so I talked to him and he said he had received calls and texts from a T. Willis.
Did he
but
say?
He didn't know who that was.
Other than that issue, was that the only issue he had to make him want to withdraw?
I don't recall. That was the basis for the bond being revoked. And that was the basis for his motion, that he hadn't had contact with the client to prepare the case.
Okay. Is anything else
That's all.
Okay.
Anything else?
No, Your Honor.
Step down.
On the second call, I would like to call Mr. Vaughn.
Mr. Vaughn, raise your right hand, be placed under oath.
I do. Were you here in court on November the 12th?
I was.
And did you see the defendant, Mr. Tanyan Willis, here that day?
I did. I believe he was late, but he was here.
All right. And did you, are you familiar with the grounds for the withdrawal?
Yes, it was my understanding and my recollection that Mr. Richards cited Rule 1 as the main basis for his motion to withdraw, and then cited the non-contact from Mr. Willis as well, and it being revoked based on the non-contact, but I believe Mr. Richards' whole motion surrounded him not being paid effectively, is my recollection of it.
That's all the questions I have.
You represented Mr. Willis
I did.
for a period of time.
I did.
Did you ever have communication issues with him?
No, he was in jail.
Okay.
He was in jail. He was easy to find.
So in your dealings with him, he hasn't been not in contact with you?
No, he and his family were very much in contact with me from the November date to, I believe, when he hired Jake in January. I talked to him probably multiple times a week. It's visited with him, I think, twice.
But you are aware he does have a pretty extensive criminal history.
I suppose so.
And in your experience, when someone is familiar with this system, should they know to be in contact with you or whoever the lawyer is?
Yes, they should know that, but they don't always. But I think Mr. Willis was.
Okay, that's all I have.
Do I get a turn?
Anybody else want to testify? Come on. You want to argue anything, Mr. Locker?
Yeah, I reserve the judgment.
They have any argument to make?
I don't want to talk about this anymore right now.
Well, herein lies my concern. The motion to withdraw that was filed by Mr. Willis states the following: comes now S.S. Richards and moves this honorable court to withdraw as counsel for defendant Tanyan Willis and that the defendant be given 30 days to retain new counsel. As basis for the motion, counsel will show that pursuant to Tennessee Supreme Court Rule 1.16, counsel has cause for withdrawal of further representation of the defendant. Additionally, counsel would further state that communication is broken down, which has prevented counsel from being able effectively and adequately prepare. Accordingly, counsel effectively cannot represent defendant in this matter. Then the court heard that, and at that point in time, there was a motion to withdraw that was filed, and then that was heard by, and there's no order in the file that shows that the action of the judge, it just is a docket entry that says motion granted, bond revoked due to no contact with attorney. Now, there is several notations that state that were checked, for example, on a stamp here that says when it was reset previously for the November 13th trial date, it was checked that that he would have to keep in contact with his attorney. So that was apparently the basis for the withdrawal and the basis for the judge revoking the bond. Proof has been before me that apparently Mr. Willis did appear on the date, has appeared in court, and did apparently attempt to stay in contact with his attorney. Purpose of a bond is to ensure that a defendant who is charged with a crime and presumed to be innocent of that crime until such time as the state proves his guilt beyond a reasonable doubt is allowed to remain free, and that a bond guarantees their appearance in court. Bonds are supposed to be set no greater amount than is required to ensure the appearance of the defendant. And there's a whole set of statutory factors that the court has to apply to be able to ensure that the bond is set for an adequate amount to ensure the defendant's appearance. In this particular case, I don't know Attorney Richards, don't have any idea of whether or not there was anything more said that day than what was said, but the only entry in the record, the only basis for the revocation of his bond was his failure to stay in touch with his attorney. that is now somewhat suspect based upon what I've heard from both Mr. Vaughn, Mr. Lockhart, and from the defendant in this case. I am very reluctant to go behind what another judge has done, but by the same token, if the case is on my docket, it would appear to me that the motion to reinstate bonds should be granted solely because of the fact that, number one, I think the reason for the revocation of the bond previously is questionable. Number two, he now has retained an attorney to represent him that I'm quite familiar with, and Mr. Lockhart's well aware of our proceedings and our standards in this court, and that I have to have some confidence that Mr. Lockhart will maintain contact with his client and will be allowed to get this case ready for trial. Is there any reason that he cannot maintain or cannot continue on this docket? That except
He has to with this conflict.
all right. With Mr. Lockhart as the attorney, I'm going to order that the motion is granted. Now, question arises as to the bond has been revoked. It was made by Pardue Bonding. So the question is whether or not Pardue Bonding will remain on the bond is up to you and Mr. Pardue. But I'm going to reinstate the original amount, which is $25,000 according to what I've seen. So the bond will be reinstated to $25,000, and if Pardue Bonding is willing to remain on it, then he'll be allowed to stay on that bond. Now, we need to set it for trial, or do we need to set it for the July?
This is an older matter, and if this goes like I think, we should probably do the July trial date.
What? We have July the 17th. On the we have the 23rd and the 24th of July.
Seventeenth be the state's preference.
Which,
17th of July.
right? Now, in view of that, because this is an unusual circumstances, do you want a final plea day before the 17th?
I believe I've already given Mr. Lockhart an offer. I don't know how to handle that with you. He won't be, I don't know if he can give me an answer on that because my offer.
Has it got an expiration date to it?
It doesn't, it's got to, but, sounds like it'd be the 8th, but if you honor, I know the court's policy now, but if we could have an exception.
Well, this is an unusual circumstance. That's the reason we're having this discussion is that, rules are, not written in stone and, and we're trying to adopt a new process that will eliminate having trial dates that are set for cases and they never go to trial. So what I'm telling you is that if you want a final plea day, I can give you a final plea day. If you think there's a base, do you have any discovery or anything that are you needing time to prepare? I know that you're probably adequate as far as.
No, I can be prepared and go through discovery and be ready on, if we're talking a July 8th appearance date, I can be ready.
But let's set it for July the 8th will be the final plea day. And then after that, the trial date will be the 17th.
Yes, Your Honor.
All right.
Thank you.
Okay, and with that, we're going to go ahead and leave it for today. I appreciate you joining us here on the Courtroom Files Live. We've just completed our first full week, kind of off calendar, but 5 days worth of shows. Keep getting better at it every day, Doing lives is different from doing videos, which is different from doing shorts, but we enjoy all of it, and we hope you do too. Anyways, I did want to circle back real quick before we go. We started the day in Judge Meineke's court where he was doing sobriety court, and just kind of a refreshing way to start the day and watch people that are trying to improve themselves. He actually spent a full 2 hours with that group today. working with them and checking in on them and complimenting them on their progress and helping them move along. So those are good things to see. Not all judges stream their sobriety court. Judge Middleton actually said earlier when he was talking with somebody about sobriety court that he does not stream it, but Judge Meineke does. So that was good to see. Anyways, thanks again for joining us. We will see you again tomorrow, 10 a.m. Eastern, 7 a.m. Pacific. Thanks so much, and God bless.